What is the process of actually getting anticipatory bail? I thought I'll have to talk about this because one of my clients, who after several months came back to me after dropping a project midway, comes and says that I've been falsely accused of this offense by my ex girlfriend, for which he had come to me in the first place. He had dropped it, and then several months later, he came to reinitiate the case because his ex girlfriend finally initiated that false complaint against him that he was afraid that she's going to do. Asks me, सर एंटिसिपेटरी बेल ले लेते हैं उसके बाद चले जाते हैं पुलिस पे. सो आई सेड भाई साहब ये कहीं दुकान पे नहीं बिकती है एंटिसिपेटरी बेल. डू यू अंडरस्टैंड द होल प्रोसीजर? ही सेड नो. एंड देन क्लियरली बीइंग अ क्लाइंट ही स्टिल डिड नॉट वॉच एनी ऑफ my videos. And I thought to myself, sure, I mean, anticipatory bail is something that I've talked about a lot, but maybe there are people out there who don't understand exactly how do you get anticipatory bail. And so therefore here we have the video on how to get anticipatory bail, or at least what is the process of applying for and getting anticipatory bail. So I explained to the client as well this particular thing, which is that you tell your lawyer all the facts of the case. Your lawyer then drafts your anticipatory bail application, after which you verify the contents, you approve the contents of that anticipatory bail application. You then send it back to your lawyer. The lawyer then prints it out. You come over, you sign the affidavits and the wakalatnama in favor of the lawyer. The lawyer then goes and prints out the index, puts on the court fee, attaches the forms that you have to fill out, and then you go. The lawyer, that is the whoever the lawyer is for that matter, goes and files that bail application in that court. Earlier, pre-pandemic, used to go and file it in the courtroom, in the court complex, going to the registry, the filing counters. And nowadays they even accept it via email. Either which ways, once we file it, in fact, counters, the filing counters, it's a little more streamlined process. If I file it before 12 o'clock today, in all probability it will be listed tomorrow. And if I file it after 2 p.m., it will be listed day after tomorrow. That is how it goes, at least in the great city of New Delhi. Now, after the filing, they list it, and if you are online, if you do it online, they will reach out to you and tell you that in another 2 or 3 days, the matter will be listed before the judge. When the matter is then listed before the judge will issue notice to the police station which you have mentioned and will ask for a reply to the anticipatory bail application that you have filed. So a copy of this anticipatory bail application that you have filed with the court will go to the police station as well. And then on or before, usually on the date of the next hearing, the police officer will come with a copy of the status report or the reply, which will usually say something to the tune of the allegations are very severe, maybe recovery is still required to be effected, custodial interrogation is required, the offense is very, very severe, and therefore anticipatory bail should be denied because custody is required. I have till date never ever ever seen the police come to the court and say that the anticipatory bail application may be allowed because we do not need custodial interrogation or custody, or that the offense is not that severe. Because if it wasn't that severe, in all probability it would not have been a non-bailable offense, and it would have been a bailable offense for which bail would have automatically been granted by the police without any intervention by the court anyways. So the arguments happen maybe on the same day, maybe on the subsequent date of hearing, and then after that the judge will pass his decision. If all goes well, you get anticipatory bail. If all does not go well, as I have discussed in other videos, your first line of approach is the sessions court, where you have filed this first anticipatory bail application under section 438 of the Criminal Procedure Code. If it doesn't happen there, then you move the High Court again under section 438 of the CRPC and you seek anticipatory bail over there. If that does not happen over there, then you go to the Honorable Supreme Court in a special leave petition challenging the order of the Honorable High Court, which has dismissed your anticipatory bail application. So you file your special leave petition under Article 136 of the Constitution of India against the impugned order of the High Court dismissing your anticipatory bail application. And Hopefully the Supreme Court will grant it. If it does not, then you have no other option but to surrender before the court and then seek your bail. Anyways, I went a little too far ahead. The point that I was trying to make was assuming that the offense is not very, very serious and you have good grounds to convince the court that yes, this is a good case for grant of bail. Grounds perhaps being you being completely innocent and you having some sort of proof to make it absolutely sure that you are completely innocent, or the case otherwise, because of maybe the severity not being that much, maybe there is a huge amount of delay in reporting the incident, and many other factors which have been discussed by several judges and judgments in court complexes and courtrooms every single day, hundreds of times every single day. On those considerations, hopefully, if you are getting bail, then this entire thing will be the process of getting bail. It is not something that you can get in a couple of hours or maybe even in a day or two. Anticipatory bail usually is something which takes you minimum of about a week or so to get. Having said that, another thing that I would like to add is that if it is going to take time and you are afraid that you will immediately be arrested, you go to the court and the first day itself there is a chance, a lot of times the judges also grant you interim protection, which means that the very first day you approach before the court, because even then, even before the matter is listed, the a copy sometimes, quite often also in fact, goes out to the police station as well. And so even on the first hearing date as well, the police officer could be ready with the reply, or could be ready with at least standing in front of the court and be ready to rebut the arguments which are being made before the judge. And if the investigating officer is there, or if the public prosecutor is there is a very good chance that you can get interim protection as well, which means that we will listen to the matter on merits on the next date of hearing, but until then at least, so that you can go about your daily affairs, but not because of that, but usually because you need to join investigation. And yours is a good case where the judge feels that yes, it's a false case or your custody is not required, you can then join investigation by getting interim protection, which means that when you go and appear before the investigating officer, he or she will not immediately arrest you. And so that is very, very helpful in most situations as well. This is the beginning, the end, the entire story of how to apply for and the process of applying for and being granted anticipatory bail by a court of law.